Hi, and welcome back to Kelly's Take Two pre-licensing Zoom review. We've been going through the North Carolina Standard Offer to Purchase Form 2T. We're just flying through it like a speeding bullet train. Not, but we're about to go ahead and dive into our final section. We left off on page 11, I believe, is where we're going to start. So if you want to grab your own copy, if you happen to have one, go ahead and get that ready. And we'll start at the top of page 11. Let me share my screen with you if you want to follow along that way. All righty, so we left off talking about the home warranty, and this is just the last bullet point regarding the home warranty, if there is one. There you go. Okay, let's slow down and talk for a minute about risk of loss and condition of the property at closing. This is a good one. This really brings in a few different concepts. So let's go ahead and talk about and slow down here for number 11 regarding risk of loss and condition of the property at closing. This paragraph, or a few paragraphs, actually brings in a few different topics that are very interesting that you're going to want to know about. So I'm going to read it to you because it's pretty important. It says that the risk of loss or damage by fire or other casualty, hurricane, tornado, tree falling on the house, those sorts of things, prior to closing shall be upon seller. Seller is advised not to cancel existing insurance on the property until after confirming recordation of the deed. That's a big deal. Okay, let's try this next part. Buyer's obligation to complete the transaction contemplated by this contract shall be contingent upon the property being in substantially the same or better condition at closing as on the date of this offer, reasonable wear and tear accepted. If the property is not in substantially the same or better condition, then the buyer may choose to terminate this contract by written notice delivered to the seller, and the earnest money deposit shall be refunded to the buyer. If the buyer is not in, if the property is not in such condition and buyer does not elect to terminate this contract, buyer shall be entitled to receive, in addition to the property, the proceeds of any insurance claim filed by seller on account of any damage or destruction to the property. Isn't that something? So essentially it says that if a tree falls on the property 2 days before closing and the buyer still wants to purchase the property, that's a-okay. The buyer will have access to the seller's insurance proceeds. Number 12 is a good one as well. It tells us what happens if somebody is causing the closing date to be delayed. Well, it used to be that you had a maximum of 14 days that the closing could be delayed before we were in what's called a voidable situation. But that has been greatly reduced down to a mere 7 days. Ooh, that makes me nervous just thinking about it, because there will always be delays, y'all. That just really makes me nervous. We'll see how it's going to roll out. That's brand new this year, that adjustment. So what it's saying essentially is that the non-delaying party, if the delay goes on more than 7 days, the non-delaying party may choose to either move forward or terminate the contract, again, without penalty. Okay, very good. And then it also says the non-delaying party may terminate the contract without penalty, meaning they get their money back, but they might also be able to seek other remedies that might be available to them. And what we know with our contract is the buyer has substantial number of remedies when it comes to the seller breaching the contract. But if the buyer breaches the contract, the seller just has one remedy, and that's in the form of what's called liquidated damages. That would be the due diligence the due diligence fee and the earnest money deposit together. Together, those will be called liquidated damages for the seller. All right, let's keep going. Possession is at closing, and all devices should be included, garage door openers, keys, those sorts of things. If there's going to be buyer possession before closing or seller possession after closing, we are advised to use a few different forms, as well as, here we go, watch this. Let's slow down for a second. This is important. Here we go. If one of those situations happens to occur, we as the broker ought to advise our buyer or our seller to pick up that phone. Who are we going to call? No, we're not calling Drake. We're going to call the insurance agent to find out what adjustments need to be made to policies to completely protect the buyer or the seller. So remember that. That's a big one. Okay, let's go. Number 14 is a list of all other forms available to us to use. Sorry, that's not going to let me do it. All other forms available for us to use as realtors if we need additional items to be handled. For instance, are we selling a vacation rental? Then we're going to use a vacation rental addendum. Are we selling a short sale? Then use the short sale addendum. Are we getting a FHA or VA financing? Well, let's attach that addendum as well. Is the home built prior to 1978? Well, let's by all means use the lead-based paint addendum. So a nice list right there. Also, if you are working with a client and they have an attorney draft their own addenda, then go ahead and check that box and describe what that is, what that looks like, the title of it. We're just reminded right here in this note box that real estate brokers are not allowed to draft contract language at all, period. Oh, but there is one exception. If you know the exception, give yourself a pat on the back right now. The exception to that rule is if the real estate broker is a direct party to the contract. What does it mean to be a direct party? If you're signing the contract, you're a direct party to the contract in general. All right, so in that instance, you can make some changes to contract language. Not that it's a good idea, but you could. Number 15 tells us that a contract may not be assigned to anyone else without the permission from all parties. So this contract is not really assignable unless all parties agree to it. Number 16 tells us about a tax-deferred exchange. Is the buyer going through a tax-deferred exchange? And if so, this is to let the seller know that they should not incur any additional costs or liabilities because of going through the tax-deferred exchange. You'll learn about the tax-deferred exchange in Unit 18. That's a fun topic. All right, we're moving on to page 12. Number 17 lets us know who the parties are to the contract and that this contract will transfer to the heirs in case of death. Number 18 talks about survival. So if there was a specific provision here that's required to be observed and it's going to survive the closing until it's completely performed. Number 9, I'm going fast right here for a reason. Number 19 tells us that even if there are multiple copies of this form, this contract form, it really creates just one actual contract instrument, essentially, and that it is it's the best proof of what the parties are agreeing to. So this is, therefore, if we have a contract dispute, oral evidence will not be allowed in the court to override what is in this contract form. And by the way, speaking of that, if there is an argument related to the contract and the parties go to court, if there happens to be an addendum that's attached to the contract that is addressing a certain specific issue that the buyer and the seller wanted to have addressed, that will override potential contract language. That will take precedence, shall we say. All right, number 20 says that in North Carolina, that the transaction This transaction may be done electronically, and that's due to our rules related to the Uniform Electronic Transaction Act. And that the information called notice information below is not a material part of this contract. Very good. Neither is acknowledgement of and receipt of monies as well. Those are just add-ons, and I'll show you what those look like in a minute. Number 21 says that this contract may be signed in multiple originals, but all together constitute one and the same contract instrument document. There you go. Number 22 is where we're going to learn how to count days. Like, we really need that. Apparently we do. Apparently we do. So I'm going to read this to you in my very best Monty Python voice. If you can guess the reference, the actual Monty Python reference, my last class did not guess it. So maybe you did. Put it in the comments if they're open. Put it in the comments below. I just love that we have to be told how we're going to count the days. All right. Unless otherwise provided, for purposes of this contract, the term days shall mean consecutive calendar days, including Saturdays, Sundays, and holidays, whether federal, state, local, or religious. For the purposes of calculating days, the count of days shall begin on the day following the day upon which any act or notice as provided in this contract was required to be performed or made. Any reference to a date or time of day shall refer to the date and or time of day in the state of North Carolina. And the number shall be 3, and 3 shall be the number. I'm just joking around with you, but if you get the reference, let me know. Who knows what you might win? For today, it's nothing except smugness. All right, we started with paragraph number 23 on remedies for breach of contract. So I'm not going to go over it again. Go back to the first video and know that we start with this on the first video. Also, go ahead and put a big box around it, stars by it, because this tells you exactly what happens with the earnest money deposit and the due diligence fee if a party breaches the contract. That's page 12. Let's go down to page 13. This is where the buyer and the seller, the parties to the contract, sign. You sign here if you're dealing with a corporation. This little area on page 13 is a warning about wire fraud. Be very, very, very careful. You always want to verify the wiring instructions with, if not once, if not twice, verify the wiring instructions. People have lost their whole life savings and the equity of their home by having the money wired somewhere else. And it's we've seen a very strong uptick in wire fraud lately, so be careful of that. Page 14 is the notice of information. How do we get in touch with a buyer? How do we get in touch with the seller so that we can easily get this transaction completed? All right, here we go. Confirmation of agency notice. This is where the selling firm that represents the buyer will fill in their section. Is the selling firm acting as a buyer's agent, seller subagent, or a dual agent? Put your license number in there for the firm. And then the individual selling agent representing the buyer, are they acting as a designated dual agent, which, as you know, is fairly rare, although it seems to be gaining popularity, but is fairly rare. But if you are acting as a designated dual agent, could be sure to check that box and then put your license number and contact information. Alrighty, and then the same rule applies over here regarding the listing firm. Is the listing firm acting as a seller's agent or a dual agent? What's the firm's license number? The individual listing agent, are they acting as a designated dual agent? And what is their license number and contact information? And last but not least, page 15 is a little worksheet, which is great. So if typically it's the buyer's agent, if the buyer's agent is delivering checks to the listing firm, they're going to want to have someone sign off that they have received those monies. All right, thank you guys for watching this offer to purchase Form 2T review. I hope you find it helpful now and in your future career. You can always come back to this if you're confused about what a certain provision means. Have a wonderful day, and I'll see you next time. Don't forget to subscribe.